Creation of an independent seniors advocate in the province. We're working together with Manitoba and Alberta in our drive to get the governments to form an independent seniors advocate for each of these provinces. We also are pushing forward looking for fully funded high-dose flu, pneumonia, and shingles vaccines, which currently are not funded by Saskatchewan Health Association and therefore cost quite a bit for individuals to purchase these. And then finally, we are looking for long-term care and home care reform, which is desperately needed and became so very apparent to absolutely everyone with the pandemic. So, welcome to our first event as C.A.R.P Saskatchewan. Today we're going to be talking about common mistakes made in estate planning. Our speaker is Ruth Pradzynski. Ruth graduated from the College of Law at the University of Saskatchewan in 1977 and has been practicing in the province ever since. She started our law in 2005, focusing on the areas of real estate, wills, and uncontested family law. Ruth is married, has 3 children and 7 grandchildren. In her spare time, she writes novels and plans to publish 7 novels in the Cozy Home to Sherwood series in 2021. It gives me great pleasure to introduce Ruth Pradzynski. Ruth?
Hello, everyone. So nice to have you here, and let's talk about 10 common mistakes made in estate planning. So the first one is not having an estate plan. Statistics indicate that approximately 50% of Canadians do not, in fact, have an estate plan. And if you like, you could just raise your hand if you're one of those 50%, because that really is carrying denial too far. The reality is none of us get out of here alive. And at some point, we are going to need a will. So I have a little story about that. I had a situation just after I became a lawyer. My first estate was an elderly bachelor who died without a will. What happens if you die without a will is that you actually get the will from the Intestate Succession Act, which is the government-made will, which leaves your estate to your next of kin. Now, this elderly bachelor had one sister who had been looking after him for the last 10 or 15 years. If he'd had a will, he probably would have left everything to her. But he didn't have a will, and so it went to his next of kin, which were all of his brothers and sisters. He had 19, of which 10 he had never actually met. His father had remarried late in life and adopted his spouse's children. So 19, instead of having one person, there was 19, some of whom the person did not even know. And that's the problem if you don't actually have a will. You get the will under the Intestate Succession Act, which often is not what you would have wished. Number 2, having an inadequate or invalid will. And I've seen this happen many times. It's possible to download a will kit from the internet or to go down to a stationery store and pick up a will form and fill out your own will. And so people say, well, why would I ever pay money to a lawyer to get a will done? And the answer is that it's real easy to do an invalid will. And I've seen a lot of them. In order to have a valid will, it has to be either entirely in your own handwriting, or it has to have 2 independent witnesses. Had situations where people have come in, brought in their will that they thought was valid, and they filled in the blanks in a will form and then signed it. That's not a valid will. I've also seen cases where people died with a will that they had copied out entirely in their own handwriting, but they didn't really understand the legalese. And so they ended up appointing an executor, but not dealing with their property. So most lawyers don't actually charge a lot of money for wills. We consider this a public service more than anything else. And so please give us a call. Let's see if we can help you. Number three, failing to appoint a guardian for your children. Who would look after your children if you and your spouse were killed or incapacitated in a common accident? Does everyone in your family know what your wishes are in this area? This is a big issue. I have another story here about an immigrant family who were tragically, both the husband and wife were killed in a fire in their apartment. The children were at school and they were not killed. And what happened was that the parents did not have a will, and the children ended up in the care of the Department of Social Services, while both families fought for who should be looking after the children. That's not what anybody ever wants. So getting that guardian in place is so important. Number 4, not having a living will or healthcare directive. End of life issues are becoming increasingly challenging. Medical science now can keep a body alive for a very long time through artificial means. Is that the kind of thing that a person wants? Or would you like someone else to make those decisions for you? Or would you want your own deeply held beliefs and values to be expressed? Well, that's what the healthcare directive does. It can set out exactly what you want, how far you want your medical people to keep you alive, and where you want them to let you die. And those things are very important. There are situations where people have not had a healthcare directive, and it has led to immense family conflict. There's a famous case out of Florida of a lady whose husband was sure that she wanted to be allowed to die, and her parents were desperately opposed to it. And by the time they actually took the matter through court, the family was so much disunited that they could not attend a funeral together. Next one is failing to provide information about your assets to your executor. There are millions of dollars of assets that are lost because the executor doesn't know about them. Have you listed all of your property, all of your assets, so that your executor can find it? There are many, many bank accounts that are not located and not found, and that just simply go to the bank. So the next one is failing to provide appropriate contact information. When you do up a will, you have a choice as to what you want, where you want it to go. Some people take their wills with them. Some people leave their wills with their lawyer. Either option is fine, as long as those who are going to be handling things know where to find it. But frequently that is not the case. Practically every month, you get phone calls or emails of lost wills. People were sure there was a will, but they cannot locate it. So very, very important when you do a will that you make sure that you let your family know where to find it. So the next issue is not updating wills. When things change, the will needs to change as well. You should be reviewing your will every 3 to 5 years. Chances are good that beyond this time, your circumstances will have changed to the extent that your current will is outdated. And one of the things that needs to be dealt with here is the issue of common law spouse. Did you know that if you've been living common law for a period of 2 years or more, your will that you made before you entered the common law relationship may no longer be legally valid? The government of Saskatchewan has changed the definition of spouse in all of its legislation to include common law or same-sex partner. And what that means is, under the Wills Act, if you get married, if you have a spouse, then your previous will is no longer valid. Well, if you are in a common law relationship for 2 years or more, your previous will is no longer valid. And one of the things that really needs to be talked about in terms of this is, in terms of estate planning, is what are your intentions in regard to your property and your common law partner. Often this, in terms of a second marriage or a second relationship, people may intend that they're leaving it to their children rather than the new partner. Well, if you do not have a will, what the Intestate Succession Act says is that the spouse gets the first 200,000, which for many people is the entire estate. If that's not what you want, you need to have a will so that it clearly sets it out. And you also need an interspousal agreement. Under the Family Property Act, if a spouse can at any time during the marriage or in regard to the estate, apply to the court for a division of property. And basically the assumption is it's 50-50. Now that might not be what the two of you talked about, but if you do not have a legal contract, which would be probably a cohabitation agreement or a prenuptial agreement, that what you're stuck with is the Family Property Act, which says 50-50. If that's not what you want, you need to have the agreements in place to make sure that what you do want is what happens. And there's lots of problems where people simply assume things are going to be taken care of appropriately, but they have not got it in writing. So the next one is not having a power of attorney. The power of attorney is the document that you need to deal with your property if you are unable to do so yourself, but you are still alive. As soon as you die, the will takes effect, not the power of attorney. But the power of attorney is the document you need, for example, if you become incapacitated, if you get dementia, or if you are out of the country and cannot deal with your property. You need a power of attorney to handle it while you are unable to do so. I don't know how many times I've had people phone me up and say to me, Ruth, would you mind going down to the nursing home and do a power of attorney for Uncle so-and-so? And so I'm saying, well, how is Uncle so-and-so? And frequently what I hear is, well, he has his good days and he has his bad days. Guys, that's too late. We don't want to be in a situation where I'm trying to find mental competency where it may not be in place. You have to sign a power of attorney while you are mentally competent. And that means you need it before you need it, so that when you need it, it's in place. It's sort of like insurance. We all hope that the power of attorney is a document that you're never going to need, but you have to sign it before you need it. Because once you're not mentally competent, it is too late. And your family would have to apply to the court for a guardianship order, which is very costly. And then number 9, specifying the assets in the will in too much detail. I've got a personal example of this. In my father-in-law's estate, he said in his will that he was leaving his truck, his red truck, to his son, Walter, my husband. And then before he died, he gave the red truck to his 2 grandsons, and he bought a white truck. And this was a problem because as far as my husband was concerned, his dad intended for him to have his truck. But as far as his sisters were concerned, his father said red truck. And so the red truck no longer existed because it had been given away. And so the gift simply failed. Well, of course, the difference was whether or not my husband was going to get the truck. And that's the kind of thing that simply means if you specify assets in a will with too more much specification, you're going to be changing your will all the time to update it so that it's still appropriately in place. Doesn't have to be that way. What we regularly do in terms of a will is that we put in a clause saying that it's our intention to make a list of assets that we want to go to certain people, and we ask our executor to deal with that list. And it's a lot easier to change the list than to change a will. And finally, not talking to family members about your estate plan. I know people are often very secretive about what they're putting in their will. And I would encourage you not to do that. In my experience, and I've done many, many wills, when people do a will, they have a reason for what they're doing. For example, I've had situations where people will leave one of their sons or daughters out of their will. And they'll say, well, so-and-so, I already gave them more than a third of my estate previously, and it just wouldn't be fair to the others to leave them in the will. Or sometimes it's a situation where they have an addiction problem and their family member, they're concerned their family member would actually die if they gave them a share. There's always a reason. But if you don't talk to your family, what happens is they feel that they're not cared for. They feel that you forgot about them, or that somehow you've offended them, or they've offended you, or it leaves for hard feelings in the family. And there's no reason for that. Like I said, people have a good reason for why they're doing what they're doing, and they need to talk to their family members about it. The family then does not need to be hurt and divided because of what was done in the will. So that's my 10 common mistakes made in estate planning. And I'd like to open it up for questions.
Thank you very much, Ruth.
Kathy, we're not getting your audio right now.
I don't know what.
Questions coming in while you've been talking, so people are obviously paying attention, and I'll just read them out for you.
Okay.
So I'm not muted, but I'll turn my camera off in case that's the problem. Can you hear me now?
It still looks like you're on the planet that was behind your...
Yeah. So the first question is that if you haven't got a will, your spouse will still get the home.
I'm sorry. Try it again.
Oh, I don't know. I think it's frozen.
Well, Kathy, let me jump in here, if I may, while your
question
microphone...
is, if you don't have a will, does your house automatically go to...
I'm only getting 1 word and 3 on this. I think what I'm hearing is, if the house is in joint names, does it automatically go to the other person? Is that what the question is?
Yes, it is. Thank you.
All right. Yes, that's true. If the house is in joint names with survivorship, joint tenancy, then the house would automatically go to the other person upon the death of the first person.
Thank you. Is it costly to name a lawyer as an executive?
Well, most lawyers, I think, probably would decline to be named as an executor. There's so many chances for conflict of interest in a situation like that. I think it's, I know personally, I take the position I'm not prepared to be an executor of an estate because if I've prepared the will and then I'm the executor as well, how many things could go wrong in terms of conflict of interest in a situation like that. So I've seen situations where people simply don't have a family member that can act as executor. Perhaps they're single and they're from out of the country and they just don't have anyone that they feel could do that. And there are some law firms that are willing to do it, to take it on. And probably they would do it and they would charge. I know I had a situation like this with a client not too long ago, and I checked in with a law firm and they said, yes, they would do it. They would charge, I think, 2 or 3% of the value of the estate in order to handle the executor, acting as an executor. So not free.
So how many executors would you suggest that someone has?
Normally, I recommend that people have at least 2, one executor and then an alternate in case the first executor passes away.
Okay. Is it wise to have family members as an executor, or is it safer to have someone who's not in the family?
Well, people do it all the time. And the issue is the character of the family member. I mean, we all know certain family members that it would be a really, really bad idea to have as your executor, either because they are not good at managing their own affairs and so they're not going to do a good job on the estate, or they're dishonest. Either reason would be a bad reason to have that family member. But we all are aware of family members that are just absolutely organized and who are the soul of integrity, and there's no reason that they can't act as executor and do a very good job. So it depends on the family. I have had clients who have said to me in so many words, no, I have no family member that I would be comfortable naming as an executor. And so then we have to look for people outside the family. But most people will select a family member as their executor. In fact, most couples will select their spouse as their first executor.
Thank you. Can a power of attorney change a will if you are incapacitated and circumstances change? For example, if a spouse or a designated heir dies after you become incapacitated and the power of attorney is in effect.
The power of attorney they can't change your will, but
Right.
depending on the powers given in the power of attorney, they can change your property. So, for example, a power of attorney can arrange to get their name put on your accounts or on your titles so that the titles and accounts go to them in the event of your death.
So someone's asking a follow-up question that says, as a power of attorney for my 89-year-old father who is incapacitated with dementia, is there a way I can get his will from 1984 updated?
No,
No.
you can't. Well, he's not longer mentally competent. He cannot do a will. So they're stuck with the 1984 will.
If you're nominated as an executor, but you decline the task, what usually happens?
Oh, it's a mess. I've seen situations like that. Now, sometimes there will be another family member that is willing to do it. And that's great if that's the case and if they're suitable. I mean, the issue here is this person responsible and reliable adult? And if so, great. They can take over and act as executor. But the reality of life is that's not the case for everybody. And so when you have somebody that is actually not a person of integrity, they can take the assets of the estate and keep them. And it's a big problem.
So there's quite a few questions about dementia, actually. One of these is, what does a person with early dementia, memory loss do, who does not yet have a will? This person still makes their own decisions, but they are forgetful and have poor short-term memory.
Okay, well,
What do you do when you haven't made a will?
okay, in terms of that, you can still make a will if you can know what you have as assets and know who your family members are. When you get to the point that you're not recognizing your family members or being able to know what the extent of your assets are, that's when you are not mentally competent to make a will. So a person could still have some problems with short-term memory and yet still be mentally competent in terms of making a will. And the requirements for making a will are they must be able to know the extent of their assets and they must be able to know who their family members are so that they realistically can actually say, yes, I'm leaving to these family members.
Okay. Do you have any suggestions how families can be sure they can find the paperwork and documents for a sick or deceased person? Is there anything a person can do?
So the problem, I didn't hear the whole question, but I'm going to guess that you're asking about documents that can disappear.
Yes.
Okay, so there are
Yeah.
some things that you can do. The courts actually allow you to register your documents at the court. And so then you know it's not going to disappear. One of the things you can do is actually file your will with the court and they will keep it in a safe location. There is also a new online place that will keep your documents for you as well. And I'm just trying to remember what the name of that business is. I think it's called Notice Connect. And it's an online place, and I believe they will also keep your documents in a safe place. And the other thing is that law firms will do that as well. They will keep your documents for you. They normally will have a safe that they keep them in. And the key thing is that you need to notify family members where the appropriate documents are. And then they're not going to disappear.
Thanks, Ruth. I'm sorry the connection's so bad. I think you're doing really well figuring out what I'm asking anyway. Next question is, if a legal directive or will does not exist, as a spouse, do you have automatic power of attorney if your partner is incapacitated or unable to communicate?
No, you don't. There's power of attorney. So in order to, here's the thing, if you do not have a power of attorney, the person has not signed a power of attorney for you as a spouse while they're mentally competent, and then they become incompetent. In order to be able to direct, to do the direction of the property, you have to apply to the court to be named as a guardian for that person. That's pretty expensive.
So you mentioned will kits and holographic wills. Do you consider holographic wills to be a short-term solution, just temporary, or if they're very simple, are they okay as a permanent solution?
Well, they certainly can be okay as a permanent solution, but the challenge with it really is that people that are drafting them frequently have not thought through all of the issues. I mean, one of the advantages of going to a professional to help make the will is that this person has done thousands of wills. And so you know the questions to ask. And so you know I know one time what some people do is they send out a questionnaire, and I don't do that. And the reason for that is, in order to get all the information that you need to do a proper will for somebody, you need a 16-page questionnaire, and it's just not going to come back. People look at that and go, what? So it just makes a lot more sense. What I'm doing now because of COVID is I'm taking initial instructions either by Zoom or on telephone. And that works fine. And so basically we have a conversation between myself and the client, and we talk about their family and what kind of relationships they have with their family and potential issues. Does this person have an addiction problem? Does this person have an integrity problem? I mean, we need to know those kinds of things before you make decisions as to who's going to be executor and who's going to be guardian. If there are family members that hate each other, that are going to be fighting, you need to know that, and you need to know how are we going to deal with that in terms of the will. So yes, it's possible to make a holograph will, and if everything is great in the family, it may be fine. But in a lot of cases, a holograph will is a little bit too simple in terms of the complexity of family issues and that need to be dealt with.
Thanks, Ruth. There's quite a lot of questions about executors. One is, I was named as an executor, but I was never asked. And when I found out the lawyer involved wouldn't give me a copy of the will, is that normal?
Well,
I don't know.
here's the problem in terms of dealing with things like this. Lawyers are subject to solicitor-client privilege, which is very, very strict confidentiality, more strict than anything else. And your confidentiality is with the client. So the person that made the will is the client for the lawyer. And so when somebody else calls up the lawyer and says, so I think Aunt Mary made a will with you, would you please send me a copy of the will? The answer is, I cannot even tell you if Aunt Mary made a will with me without Aunt Mary's specific permission. So it's not the lawyer being a jerk. This is the requirements of that we're under as professionals, that everything is confidential. And so that person would need to communicate with Aunt Mary, the lawyer would, and say, Mary, is it all right if I give your niece a copy of the will? And if Mary says no, that's the end of the question, because the solicitor-client confidentiality says, no, we cannot communicate anything without consent of our client.
Can you outline the duties of an executor?
Well, the executor's job is, first of all, to discover what the assets of the estate are, to bring them in and convert them to cash, to pay out the debts of the estate and any taxes owing, and then to distribute the funds as described in the will.
Who considers you incompetent? Does it have to be a doctor?
Well, that's an interesting question, because there are varying levels of competency. And so one of the things that we have to do as lawyers when we are doing a will is we have to make an assessment of competency. There's no sense doing, and we're not doctors, okay? So what we're looking at is, does this person understand what they have as assets? Do they know who their family is? Are they able to sit down and make a will and understand what they're doing? So quite often, when somebody's a little iffy, I will ask them to go in and meet with the doctor and get the doctor to assess their level of competency. Particularly if this is a situation where family members might end up contesting things. You want, what ideally, you want the doctor to say, yes, this person is competent. And then you're not going to have a situation later on where you've done a will with that person and then it's alleged by other family members that they weren't competent.
Thank you. I think you mentioned, you kind of half answered this question earlier when you talked about having a conversation with the family so no one was surprised, but I'll read the question out in case you want to elaborate. How can you avoid having a will contested? If someone presumed they were to inherit and then they find they're not mentioned or they're left out of the will. So how do you stop wills being contested?
Right. Well, one of the things that I encourage people to do is to name, if they are leaving someone out of the will, I ask them to give me permission to specifically say why they're leaving them out of the will in the will. Because if you just ignore that person can then say, well, look, my parent was incompetent, they forgot me. Well, no, they didn't forget you. There was a reason you weren't put in the will. And I think it's very important to put that kind of detail in the will so that it's clear it wasn't a mistake. It was done on purpose and that the person was mentally competent at the time they made the will.
Thank you. What is the average time it takes to perform all the actions required to execute a will?
Well, we usually do it in about a week. Now that's an average will. And I'll just have to say that this is, all of this can go out of the window when you're talking about a farm or when you're talking about a business, because there's all kinds of additional issues that have to be dealt with. Those are considerably more complex situations. But for an average person who's an employee, has a spouse and some children, doing an average sort of will, it can usually be done in about a week.
So talking about joint ownership of things and saying what you want to happen in a will, there's a question which is, when a daughter is made joint on an account with a parent, does that trump over what's stated in the will?
No, but it's very important to deal with it specifically. So let's just talk about joint assets, because it's definitely an issue. Quite often, we'll have a situation, for example, with a parent whose partner has died. So the house was in joint names of the husband and wife, and let's say the husband has passed away, the wife is on her own. She's making a new will after her husband dies, leaving her property to her 3 children. And I will talk to that person about the possibility of putting their executor on the title with them joint, because that saves a lot of cost for the estate and a lot of hassle for the estate. But you don't want to end up with a situation where the child that's been put on joint says, thank you very much, Mom, I inherited everything. That wouldn't be good. And so when we do that, we would have both the mother and child sign a separate agreement that the child is going on the title for estate planning purposes only, not as a beneficial owner. And so that we're not in a situation later on where either Revenue Canada then charges the child for capital gains upon the death of the mother, or where the child then claims the entire estate for themselves. So we would do a separate agreement. We wouldn't just leave it like that. And so if you don't have a separate agreement, this can be quite confusing. The parent puts a child on the title with them, but the will may say something else. And I can see that being a big, just an invitation for litigation. You need to make things very clear when you're setting things up, what your intention is.
Thank you. We have another question about joint ownership. It's a little longer. My husband died 2 years ago. He had done everything he was supposed to regarding the home, etc. What he didn't do was add my name to his stocks and shares and be charged to put them in my own name or sell them. It was suggested my husband should have put them in joint names.
Yeah, well, and that certainly does make things simpler. Like I said, I talk to my clients about the possibilities of putting things in joint names. And let's just talk about why you would do that. Under application for probate, when somebody dies, anything that is in joint names or has a named beneficiary is not considered part of the estate and does not have to go through probate. The cost of probate is quite high. The court charges $7 per $1,000 of value. And of course, when you're dealing with real estate, that adds up real quick. And not only that, but of course, the legal fees involved in terms of getting probate are significant as well. And so it can save the estate a lot of money if things are in joint names, and also a lot of time. If things are in joint names, rather than going through probate, you simply do a joint tenancy application and the real estate gets put into the other person's name. So that, again, is a much simpler process than going through the courts. So there are some really good reasons why you might want to do joint names, but you need to make it really clear what the intention is behind that and whether or not you're actually giving that to that person or if there is just being done for estate planning purposes. And that's why you need that separate agreement.
Thank you. What if there's a company in the family? What happens to it if the owner passes away, is deceased?
Well, hopefully the owner has an estate plan, because otherwise you've got a mess. And that's really a big issue. For example, supposing you've got a company and you've got 2 shareholders. These shareholders do not have a shareholders agreement or a partnership agreement, and one of them dies. What happens to those shares? Are they inherited by the widow or widower? Do they pass to the partner? If they are inherited by the widow or widower, does that mean that the partner all of a sudden is trying to run a business with somebody who knows nothing about it? I mean, there's lots and lots of issues in regard to that. And that's why estate planning needs to be done. Those kinds of questions need to be talked about and thought about and planned in advance. So ideally, let's just talk about a corporation. Suppose you've got two shareholders, two friends that are in business together. Maybe they are running a electrical business. They're both electrical contractors. They both are trained as journeyman electricians. What they would do is they would not only have a shareholders agreement, which would put in a clause that when one of them dies, the other person immediately is required to buy their shares. You would back that up with life insurance so that if one of them dies, the corporation isn't bankrupted trying to pay out those shares. They're paid out automatically through the life insurance. Those are kinds of things that can be done if you do that planning. If you don't, you've got yourself a mess.
Thank you. We've got some other questions about leaving money for children. One is, we have a blended family. Do I treat my stepchildren as my own?
Well, I mean, that's the kind of thing that you and your partner need to talk about. And talk about, I think that the key thing here is that you need to talk about it in terms of how this is going to impact the family. Because, you know, what happens when one of the persons dies and they leave everything to their own children and nothing to the stepchildren? Is that going to cause hard feelings in the family? I've developed actually a clause for my wills, because one of the things that I'm seeing happening quite often is that one partner will die and the other partner is lonely and they get involved in a new relationship. And if they don't have a prenup or a cohabitation agreement, the children of the first marriage end up losing the entire estate. It all goes to the new partner. And so that's something that we actually deal with in the will, saying that our intention is to benefit our children. If one of us dies, the other one promises that before they would get seriously involved with someone, that they'll do a cohabitation agreement or a prenup so that our children don't lose their inheritance.
So talking about inheritances, if children are named as beneficiaries of a will, what claim, if any, do their spouses have on the inheritance? What happens if the children are separated or in the middle of a divorce?
Okay, well, there are clauses for that in the will. There's a very standard clause for a lot of wills, which is called the matrimonial property clause, which says that in the event of the separation or divorce of one of my children, my intention is to benefit my child, not the person who is divorcing them. That is to deal with the Family Property Act. The Family Property Act says basically 50-50, but there's an exception to the 50-50 dealing with an inheritance where it's made clear that the person who they inherited from is leaving it to their child, not to the other person. So that's a standard clause to prevent that kind of thing.
Okay. With COVID, is it legal to hire a lawyer to write a will without meeting them in person?
Yes, it is. The Law Society has recently provided the opportunity that we can even execute wills by distance, by Zoom. It's all new. That this is very recent, just since COVID, but it is possible to do.
Okay. What's the difference between a will and an estate plan?
Well, an estate plan is a little bit broader. So a will is one piece of the estate plan dealing with the document that deals with your property upon death. But the estate plan itself will deal with more than that. When I do an estate plan with a person, I also give them a power of attorney and a healthcare directive. And depending on the situation, An estate plan may also include a change of title to put things in joint names. It may include a agreement about what's happening in terms of the change of title. So there's a number of things that can be involved in an estate plan, and the will is simply a part of it.
Okay. When leaving a legacy to young adults, perhaps young people who are under the age of 18, do you have any hints or tips about how to ensure the money is used for a worthy reason, like a home deposit or education, and not frittered away?
Right. Well, quite often what people will do is they will leave in their will a staged release. So they can say they'll get 10% of their share of the estate at age 18, and another 15% at age 23, and so forth, so that they're not getting it all at once. So that they're not getting $500,000 at age 18.
Okay. What if you have no children and you want to leave the proceeds to a charity?
That's certainly possible, and certainly is done from time to time. People, of course, will want to pick a charity that's dear to their heart, some charity that they feel strongly about, that they've probably been supporting during their lifetime. That's absolutely possible.
If you pledge a charitable donation, does that cause the estate settlement to be delayed?
I'm not sure what that question is about. Try it again.
If in your will you pledge a charitable donation, does that hold up the settling of an estate?
No, it doesn't. No.
No.
Charity is just like another beneficiary, and they get their share. Actually, the main
Okay.
thing that holds up the estate is Revenue Canada. In order to finalize the estate, you have to have a clearance certificate from Revenue Canada, and that usually takes a year.
A year. Okay. So this might be why people are asking these questions. Someone else is saying, what is the process to decline being an executor and have another family member appointed?
Well, basically, you would do a renunciation. The lawyer for the estate will help you draft that. A renunciation of executor, and have another person that's prepared to do it would then apply to be the executor under the will.
Do people have to be family members in order to be named jointly on assets?
No, they don't.
No. How can I name specific items to people without listing it in a will?
Well, you can do a list. And that's actually quite common. There's a number of different things that people do. I've heard of people, for example, putting little sticky things on the bottom of things, little stickers on the bottoms of things with the name of the person you're leaving it to. I've heard of people doing lists. Okay, the china goes to this person, this original oil painting goes to this person, you know, whatever. The tools go to this person. That's quite common. I've heard of families that play a game where each person gets monopoly money and they can bid on different items. There's a number of ways that can be done.
Yeah. So we just have a couple more questions if you're okay for a moment.
Sure.
So if someone passes away, how long does the executor have to file an income tax return without penalty?
Well, I would think it should be done within the tax year.
Okay. How much can you give to your children prior to your death to avoid inheritance tax?
Well, there isn't actually any inheritance tax. Really, the only tax that you're facing at this point is capital gains.
And then a question about tax-free savings accounts. If you have them as direct designated to your children, and one of your intended heirs die you, and you have not updated the direct designation, what happens?
Yes.
So I think that's saying if one of your beneficiaries dies, what happens?
Right. Well, you probably, when you're doing a beneficiary designation, I really recommend people do an alternate. So, for example, supposing your first beneficiary is your spouse, but your spouse could predecease you. So have an alternate beneficiary designation on your assets for the next person that you'd want to have it if your spouse predeceases. And it's really important to update those beneficiary designations. We're currently handling a court case for a situation where a person got a divorce and their beneficiary designation was never updated. And they died 6 years later. And so the beneficiary designation has this major asset going to the divorced spouse, who now says, well, we always got along very well, even after the divorce. And the executor of the estate is absolutely sure that was never the intention of the person. So it's really important to update things on a regular basis.
Okay. So last question. When someone is booked in for surgery, they have to go into hospital
I didn't get enough of that to answer, Kathy. It's just
with the Regina C.A.R.P health region called My Voice. And let's see if it gets through. So Regina C.A.R.P health region provided document called My Voice, and it had an advanced care plan template in it. I think you can't hear me.
no, I got very little of it. I mean, there was something about Regina C.A.R.P health region in My Voice. And
Yeah.
whether we can use that probably as the healthcare directive. And I would say yes,
Yes.
absolutely.
Okay.
I think it's quite well drafted. I use a similar template myself for my clients' healthcare directives. And then what we do is modify them as needed, depending on the values of the client. For example, I have clients who are Jehovah's Witnesses, and we add a clause in there about no blood products. I have clients that are Muslim, and they have particular beliefs that need to be expressed in their healthcare directive as well. But the My Voice is a nice start.
Thank you. So this is obviously having trouble working. I'll just hand over to Kathleen, if that's okay.
Certainly. Thank you very much, Kathy. It's unfortunate that your Wi-Fi is a little wonky today, but I think that we did very well with understanding those questions and Ruth's answers. I want to particularly thank you, Ruth, for an insightful look at the missteps and legalities when planning our estate. I mean, you're really opening our eyes to the need for more thoughtful consideration in doing this. It's not as straightforward as we might like to believe. So I would like to thank you for spending time with us. You've given us lots to think about. So now, just a couple of notes. On the second and fourth Tuesday of every month at 10 a.m. starting next month, we're introducing a new feature called Coffee with C.A.R.P. It's a bi-monthly chat and open mic section. We're going to be having topics such as inquiring minds, positive aging, everyday life, good news, money matters, etc. And we're going to kick things off May 11th, 10 o'clock in the morning, spring planting, do's and don'ts. So you don't want to miss that. Very informal, casual atmosphere of this online chat with C.A.R.P. On May 25th, we're doing modern media, and we'll be discussing staying connected with family and friends virtually. So watch for further information as we finalize the details on this new feature that we're going to be offering on a regular basis. And finally, if you're passionate about older adult issues, you'd like to share your talent and energy to better your community, and you are looking for camaraderie and fun, we invite you to join us. We are looking for members interested in representing the different regions of the province, now that we're a provincial chapter of C.A.R.P. It does not matter where in Saskatchewan you live. If you're open to doing virtual meetings using Zoom, for example, then come on board. Drop us an email and we'll be happy to get in touch to talk to you about how you can get involved. For more information, simply email us at sk@carp.ca, k@carp.ca. I want to thank everyone for coming. I hope that you got some great information, and we're particularly pleased to have had Ruth spend time with us today. Do have a wonderful week. Be well, be happy, and stay safe.